this system has been in existence for about 50 years, but the cases really only started coming in the last 25 years that corporations started suing governments. And in the last 10 or 15 years, what we've seen is that the amount of money that companies have demanded and that they also were paid out have increased enormously. So many people now say we're in the era of the mega cases, where companies easily ask for several billions of dollars or euros in compensation. And of the 10 largest payouts that governments had to pay to corporations that sued them, all except for one above $1 billion US. Yeah, and so of those 10 largest cases, 7 were by fossil fuel companies and 2 by mining companies. So we can already see that kind of environmentally sensitive sectors are the ones that are most using the system and are also getting the largest payouts often. And so there are a couple of cases I wanted to highlight. One is actually becoming very relevant again. Some of you might remember that in the United States, there was a big climate movement against the Keystone XL pipeline, which is supposed to transport oil from the Canadian tar sands mines into the US Gulf Coast. And there was a huge mobilization by the climate movement. And eventually the Obama administration decided to not grant a permit for the pipeline. The next thing the corporation that was going to build the pipeline, TransCanada, did was filing an ISDS case over $15 billion for compensation for the denial of a permit, something that a government is supposed to do. They issue permits, they deny permits. So for normal regulatory action, what some of my colleagues did was looking at the reasons, looked at what that would mean for under the ICS, under the new EU system, and figured that all the arguments that TransCanada, the corporation, made could have been made in exactly the same way under the ICS. So the case would have still been possible. There's a second example of actually a Canadian company via a mailbox office in the United States suing the Canadian government for a moratorium on fracking. So the regional government of Quebec issued a moratorium, a precautionary moratorium on fracking under a riverbed. And this company had an initial permit already. When this moratorium was put in place, the Canadian company used a mailbox office in the United States to sue the Canadian government for more than $110 million US in compensation. And this case has been going on for 12 years now and is about to be decided by the arbitrators. So there's another case where a climate and environmental measure has been attacked. And so what we did was looking at ISDS cases in Europe, and 60% of them, of the hundreds of cases against European governments, involved environmentally sensitive sectors. And Canadian corporations have been among the heaviest users of that system, in particular Canadian mining corporations. So the largest open pit gold mine in Europe, in Romania, in a place called Roșia Montana, there was a Canadian company was planning to build the largest open pit gold mine there. And there was a giant mobilization in Romania, tens of thousands of people taking to the streets to stop this mine from going ahead. And the government was put under so much pressure that they also didn't issue the required permits because the company didn't even submit an environmental impact assessment. And here again, the company then, a Canadian a mining company, went and asked for $5.7 billion US in compensation. That's 3% of the Romanian GDP. And here's something that we find particularly worrying about ISDS, because a lot of the proponents say, oh, well, but these cases, the companies don't win them always. And sometimes they only get a fraction of what the companies ask for. But if you are a government of a country and you get threatened by a claim of several billion euros that could wipe out your budget for education or for health. You have no idea how this case is going to go. The expensive law firms from New York threatening you with these letters, many governments understandably take the precautionary action and give way to the demands of the company. So often these companies don't have to win the cases. It's often enough to just send a letter and threaten a multi-billion-dollar claim. And that not only works in countries with maybe real budget constraints, we even have seen it happening in Germany, where a energy company threatened the government and started a 1.4 billion euro case because they didn't get the permits for their coal power station. And then the city that was issuing those permits settled the case and lowered the restrictions on the coal power plant so that the case would be withdrawn. And so there's, apart from all the money that is at stake and that can be paid out, there's a danger of regulatory chill, so that environmental and other rules and regulations are not being put in place because investors are threatening with those expensive lawsuits. And now I've mentioned quite a few examples from the US, from Canada, Romania, Germany, but I think what was already clear from the introduction, a lot of these cases, the majority happen against countries in the global south. They are often much less able to defend themselves, to hire those expensive law firms, to wait out cases for 10 or 15 years, and to don't have the means at their disposal to defend themselves. So they're even more threatened by these cases than we are in the global north. And as it was said before, the CETA would set a precedent for a European agreement that includes these kind of privileges for corporations and investors. And the EU is hell-bent on rolling this out across the world in countries in Southeast Asia, in Latin America as well. If CETA can now be stopped, it might also put a blockage into a further rollout of these types of privileges for corporations.
Thanks, Fabian. Very sobering examples, and really puts the onus on us as well to push for this to stop before it keeps going and to do more damage than it already is, and further afield. So really appreciate that. Thanks very much, Fabian.